First of all, thank you all for joining in today on a Saturday evening. And today's webinar will be covering issues of delayed payments to MSMEs, what are the challenges and their solutions. So we'll start our webinar for today. So let's start with the agendas for the discussion in the webinar today. So firstly, we'll discuss the definition of MSMEs. So what is MSME? So micro, small, and medium enterprises, right? So it is defined under the Micro, Small, and Medium Enterprises Development Act of 2006, which is called MSMED Act in short. So we'll discuss the definitions of what are the micro, small, and medium enterprises. What do you mean if you say enterprise, or if you say micro enterprise or small enterprise or medium enterprise, as per the definitions of Micro, Small, and Medium Enterprises Development Act? And what are the qualifying conditions to apply for registrations under such categories, right? Micro category or small category or medium category of enterprises. So what are the separate qualifying conditions of those categories, right? If you want to get yourself registered under the micro category, so what would be the qualifying conditions for your enterprise to apply for that registration, right? Is same The same goes for the small enterprises and the medium enterprises. And then we'll discuss the challenges and issues pertaining to delayed, default, stuck payments from buyers. So how these issues arise in the first place, and when these issues have already arisen, then how do you move forward, and how do you deal with all these situations, right? So we'll discuss the challenges and issues pertaining to the delayed, default, and stuck payments. And the and we'll also discuss the important provisions under the MSMED Act for the benefit of MSMEs, right? So MSMED Act, as you all know, that is drafted and was brought into force, was conceived for the benefit, sole benefit and facilitation of MSMEs, right? So what are all the provisions that you should know of in the MSMED Act, pertaining to the issues of delayed payment, and how are you gonna deal with the issues of delayed payment in respect to the Micro, Small, and Medium Enterprises Act. So we'll discuss some of those important provisions in relation to the solutions of recovering payment. Then, as I already stated, solutions and way forward to resolve the issues of delayed payment. So what are the recourses that you have, that you can avail for resolving your disputes of delayed payment when it has actually come into picture, or you're actually facing it firsthand, right? So what are the solutions and way forward given in a particular and peculiar set of circumstances? So what are all the available and general recourses available for recovering monies which are delayed, right, from buyers? So we'll discuss those. We'll also discuss the preventive measures to avoid such issues of delayed payment from happening, right? So that can be adopted internally in your business operations. So what all that you can adopt, which might possibly in turn reduce the possibilities of issues of delayed payment happening in the near future. So we will discuss those also, the preventive measures. And then we'll discuss the resolution mechanisms. So when we are talking of how to resolve the disputes, if that dispute has already arisen, then we'll also discuss the resolution mechanism, the different resolution mechanisms through which you can resolve your disputes. That is, one is alternate dispute resolutions. So anything which you do out of the court, in order to resolve your disputes, are generally covered under the alternate dispute resolution, because it is an alternate way of resolving dispute, right? And the classical way of resolving dispute would be to go to the courts and leave it to the courts wisdom to adjudicate the issues, right? And to finally ascertain the liabilities of the parties in the suit, or in any legal proceedings. But when we are talking of alternate dispute resolutions, it covers negotiation, it covers mediation, it covers conciliation, and it also covers arbitration. So all of these processes are streamlined. In a way, these are also statutory, because there are laws governing all of these processes too. But then these are alternate way of resolving these disputes, right? Because you do not go to the courts. Necessarily, you do not go to the courts, but leave it to a neutral party for to decide, or to facilitate, or to strike strike a mutual negotiation between the parties itself. So all of those are covered under the alternate dispute resolutions. We'll discuss these also. We'll discuss these also, and then we'll come to litigation. So as we already know that these are alternate dispute resolutions, and there is more classical way of resolving dispute, which is going to the court, and it is called litigation, which is called litigating. So what are all the laws which you should know of, which are generally touched upon in issues relating to the delayed payments and stuck payments, right? And lastly, we'll also discuss things to keep in mind while doing business for its effective management, tips and suggestions. So we'll drop some tips and suggestions that we have garnered, and we believe that can effectively streamline your operations of the businesses. It can also help you in the long run. So we'll drop those tips and suggestions for you at the end of the webinar. And so let's begin with our agendas one by one. So I'm moving to the next slide. So firstly, we'll discuss the conditions precedent to be registered as MSME under the MSMED Act. So as I already stated, that what are all the enterprise, right? And what are micro, small, and medium enterprises under the definition of Micro, Small, and Medium Enterprises Development Act. So firstly, I'll tell that enterprise as an expression has a very wide connotation under the Micro, Small, and Medium Enterprises Development Act. So any enterprise which is doing a commercial transaction, be it anywhere in the supply chain. So for example, if you're a manufacturer, or if you're a trader, or if you're a retailer or a service provider, then all of these situations, be it anywhere you are situated in the supply chain. If you're a manufacturer, it doesn't matter. If you're a trader, it doesn't matter. If you're a retailer, it doesn't matter. If you're a service provider, it doesn't matter. All of those commercial transaction undertaking businesses who are an enterprise, who have a business name, uh, would can get itself registered as an enterprise under the MSMED Act. So enterprise isn't when I speak of an enterprise, it generally covers all the businesses that you can think of, right? So enterprise have a very wide expression under the MSMED Act. Now, how it is further classified, the definition of enterprises in the MSMED Act. So firstly, the first classification that we'll see is micro classification, the micro enterprises, right? So the first category. Firstly we'll discuss about what are all the uh, enterprises, and how they are given benefits under the MSMED Act. So as per the recent notification, I would like to add this, because the first category, which includes manufacturer and service providers both in one category. So earlier, erstwhile MSMED Act only included manufacturers and service providers, but not traders, right? So anyone who used to procure goods from traders and used to sell it off to a retailer by factoring some profit to itself. So in a way, it neither manufactured any product nor it provided any services, but it only did factoring of profit by procuring materials from one manufacturer and retailing it to somewhere else. So those are called traders, right? Because they are not manufacturing or not giving any services, to so to speak. So earlier, traders, the enterprises who were into trading, were not included under the enterprises category of enterprises definition of the Micro, Small, Medium Enterprises Act. It was outside the purview of this act. So firstly, I like to speak that as per the recent notification by video 2026/6/2020, which was 3 years earlier, the MSMED, the Micro, Small, and Medium Ministry, Enterprises Ministry, MSMED Ministry, has included traders of good also under the enterprises definition, and it also includes now under the definition traders of good. But one thing which I would like to add, and I would like to keep you in mind, that I would like uh, this to be emphasized upon, is that contrary to the manufacturers and service providers, as per the Micro, Small, and Medium Enterprises Act, the traders of good, the traders enterprises are not given all the benefits which are given to manufacturers and service providers. So when I say this, I mean that if you're a trader, by definition you are a MSMED Act, and you can only take benefit from the MSMED Act when it is restricted to external commercial borrowing or external credit availment. So, as far as the availment of credit goes, it is equally applicable as it is on manufacturers and service providers. But when you are speaking of all the other provisions, let's say of speaking of provisions where you can go to MSEFC, where you can go and file a reference case before MSEFC and want to resolve your issues of delayed payment, those benefits are not given to traders of good, and those are only restricted for manufacturers and service providers. So that is the thing I wanted to keep you in mind. And after this inclusion of traders of good, we can say that all the benefits are not even extended to traders of good as of yet. So that has to be kept in mind. So that the two parameters basis which classification is made between MSMEs are investment made in the enterprises, plant machinery and equipment, and also the turnover immediate preceding financial year generated by the MSME. So the classification of micro, small, and medium enterprises, how will it be made? So that there are two parameters of it. The first parameter is the investment in plant and machinery, right? So in the first parameter, they see what are the quantum of the investment which you have made in plant and machinery, right? And the other parameter is the turnover generated by your enterprise, the second parameter. So the both the parameters of quantum of investment and turnover required for registration as under MSMED Act. So both the parameters have to be meted out. So for you to get registered under any each of these categories, right? So going forward, this is the table laying out the quantum of investment and turnover for enterprises to be registered as any of the micro, small, or medium enterprises under MSMED Act. So both the parameters, as I stated, both the parameters, investment and turnover, has to be met for an enterprise to qualify as either micro, small, or medium enterprises, basis the parameters laid out herein below. So the enterprises, the parameter of investment made in enterprises should not exceed 1 crore. So if your investment made in enterprises is equivalent to 1 crore or has exceeded 1 crore, and simultaneously your turnover generated annually has exceeded or has become equivalent to 5 crore of rupees, or less than 5 crore of rupees, or your investment made in enterprises is less than 1 crore of rupees simultaneously, then your enterprise is qualified to be get itself registered under the micro enterprises. The same goes for small enterprises. The investment made in the enterprise should not exceed 10 crores of rupees. It should be between 1 crore to 10 crores of rupees, because lower than 1 crore you'd still be registered under the micro enterprises. You'll have to exceed 1 crore of rupees, and simultaneously in turnover you'll have to exceed 5 crore of rupees to, if your investment made in enterprises, including the plant and machinery, is anywhere between 1 to 10, then and simultaneously your turnover generated annually is somewhere between 5 crores to 50 crores, then your registration would be in small enterprises category, right? And the last category is the investment made in enterprises in plant and machinery should be anywhere between 10 crores to 100 crores, and the turnover generated annually should be anywhere between 50 crores to 50 crores. And both these parameters have to be simultaneously meted out. If any of these parameters is not meeting, then your registration would not be upgraded or downgraded. So I believe that I'm clear, and we'll move to the next slide now. So now we'll discuss the reasons for the delayed payment and its consequential effects on MSMEs, right? So the first reason is not having proper documentation. When I say that you're not having proper documentation, I speak of that you have started your work without getting any purchase order or work order, so to speak. So if any buyer is approaching you for let's say any work, then the first thing that you should asks from that buyer is a purchase order or a work order, which would make a basis, which would form a basis that yes, this was the order, this was the scope of the work that you were given, and this was the value of the scope of the work which was agreed between the parties. And there might be certain terms and conditions recorded under those purchase orders or work orders. So all those terms and conditions would become the governing terms and conditions. Now, when you do not have such documents in place, then it is quite hard for you to go and prove such transactions between a neutral party or between an adjudicatory body, or before an adjudicatory body. Sorry. So when you do not have any documentation, then the other party would not be very much convinced, from let's say your pleadings alone, that yes, there was a purchase order, there was a work order, however it is not documented. But then you'd be very much at a difficult position to prove the contents of such terms and conditions as was agreed between the parties, right? So I'm sorry. So if you, as a service provider or a manufacturer, or let's say else also as a trader, if you're giving out any material, if you're supplying any material, or if you're providing any services, there has to have a governing document which governs that transaction, right? Because not having such transaction document would keep the things open ended on both the parties end, because the important provisions, like the important clauses, the important contents, such as the value of the goods or the value of the service provided, which was agreed between the parties, how the payments were to be made, what were the GST component on it, and all of such contents cannot be proved, or it becomes really difficult for one party to ascertain all these contents without having any such documents to have to give any suggestions towards such transactions that you are referring to, right? So it becomes really important for any transactions to be governed by any work order or purchase order. So and when I say work orders or purchase orders, the work orders and purchase orders generally are very brief documents which do not have detailed terms and conditions, such as is recorded under an agreement, right? So it is always preferred that you have an agreement in place, basis on which you basis on which you raise such work orders or purchase orders, or basis on which you receive such work orders or purchase orders, right? So it is quite important. I'm really sorry. So it becomes really important to have an agreement in place, because it is more detailed and more it gives out the understanding between the parties in a more detailed manner, and it's a substantial evidence of what all are the terms and conditions that were agreed between the parties, like the scope of the work, how the indemnity clause were to be operated, if there was any non-confidentiality clause or not. So all of these provisions are become really important. And if you're not having an agreement in place, then the least that you can have is the work order and purchase order of such transactions, right? And when you receive such work orders and purchase orders of such transactions, then you can supply those materials, and you can say that, okay, I have supplied those materials, and you must document each and every development in the transactions, right? So when you have supplied those materials, you should inform the other party with an email, or you should send across the e-way bill to the other party, saying that we have already dispatched the materials, and if you have any deficiency, or if you have any protest, or any satisfaction issues on the quality of the materials supplied to you, then what you can do is you can within 15 days revert back to us, saying all those deficiencies and inconsistencies that you pointed out, and we'll try to rectify those deficiencies and inconsistencies. So all of these developments should be documented, because at a later stage, when the buyer, because I have seen this a lot of time, because because whenever the buyer has to dispute in the payment, or has to delay or be or has to delay or berate the claims of the supplier, then what it does is it generally raises frivolous and false disputes on the quality of the material, right? So if all of these are documented, then it becomes difficult for the buyer also to 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 come up with such belated frivolous and false allegations at a very later stage, when already such suggestions were made by you, that if you had any dimmer or protest on the material, then you must say within 15 days of the supply of the goods, right? So all of these documentation makes the transactions more streamlined, because at a later stage, the possibility of coming up with frivolous and false allegations significantly reduces, right? So this has to be kept in mind, that all of the developments in transactions, all of the transactions as it is recorded, and recorded, and having and have recorded at both the parties end. So this has to be kept in mind, right? So the next point is extended credit periods. So continuing the transaction even after delayed payment issues, with the hope of retaining buyer client. So I've seen a lot of small MSMEs, what they do is they extend the credit period to a longer period of time, just in the hope that it would retain the buyer, or it would retain their client, right? Because it is not at all preferred thing to do so, because MSMED Act only provides for a 45 days period, right? Which the 45 days period after you have raised your invoice, the other 45 days period, the 45 days period post the date on which you have raised your invoice upon the buyer, is exempted period under the MSMED Act. For those 45 days, you cannot claim any interest under the MSMED Act, right? So after those 45 days, however, the MSMED Act provides for three times of the interest rate, which is notified by the MSME for these purposes. So then, in that situations, what happens is, after 45 days, as per the statute, you can actually claim three times the interest rate on a compounded basis, because the MSMED Act for it provide that itself, right? So you can claim those interest just after the 45 days expiry, right? So it does not make any sense to have an extended credit period beyond 45 days. So this also has to be kept in mind. The other is the challenges faced due to competition in the relevant market. Industry specific challenges, such as disrupted availability of raw materials, competitive rates with minimal margins of profit. So all of these things, that these are I've already and I've many a times said this, that all of these are nothing but a commercial wisdom of an enterprises, right? So we cannot say that this is the exact blanket rule, or this is the exact hard and fast rule on how you should operate your businesses, but these are all things that surely benefit you in having your operations streamlined, or having your operations more strengthened. So when I say that challenges are faced due to competition in the relevant market, when I mean by saying that, to tackle those challenges due to competition, our presence in any relevant market area should not be restricted to that relevant market area alone. So the industry specific challenges, such as disrupted availability of raw materials, right? So if we have only one pool of vendors from where we procure our raw materials, then it is obviously detrimental for any enterprises to rely on such one pool alone, sole pool alone, right? Because if any disruption is caused in let's say for any reasons whatsoever, then the whole, if that lot is affected, is then the enterprise also gets affected, right? Because it does not have any other option left, because the whole reliance was on the sole pool of vendors from where you used to procure your raw materials. So it is always advisable to have a lot of pool from where you can choose and pick from your vendors on any given period of time, and where you can decide, where you can have an upper hand on deciding better terms and conditions for yourself while procuring. And the other part is that your presence in a relevant market area should not be restricted to your physical presence alone. So if your presence is also in virtual manner, then your relevant area restrictions in a way gets diluted up to a greater extent, because now the physical restrictions of a relevant area does not apply to you. Now the competition, the competitive challenges gets diluted, because you are operating in a much larger relevant market area. When you are having a virtual appearance, when you have to sell anything, or when you have to sell your services or products, and when you'll have to procure anything, if you have more than one pool of resources, more than one pool of vendors, then you'll have an upper hand in deciding the or bargaining the terms and conditions, which suits you the best, right? So all of these things can be adopted, so that the challenges due to competitions, the competition in in any relevant market area gets tackled in an effective manner. The other one is no bargaining power with buyers to negotiate terms accordingly. Market share reductions, alternative materials, or service against that of MSMEs, etc. So I've seen a lot of MSMEs, while entering into a transaction with a relatively larger MNC, or a larger corporate body, then it is almost natural for the MSME to not have any bargaining power to itself, because you generally have to agree to a boilerplate clauses, right? Because if you would suggest any changes which are detrimental to the other party, which is a large corporate, then it might not take you for as a other party to enter into a commercial transaction, and it might go to the other party, which does not have any such restrictions on terms and conditions like you did. But then you also have to keep in mind that you only can compromises on things that might not get detrimental for you in a longer run. So in a longer run, if you have to retain a client which is an MNC, and if they do not want to issue a work order or purchase order for giving a work to you, then you should then according to me, or as per my view, the possibility of retaining a client, and the possibility of getting benefit from it is so much lower than the possibility of getting a detrimental damage from proceeding without any documentation, right? So always keep in mind that your bargaining power, be it less with the other party, be it an MNC, or a global company, you should not compromise upon things. You should not bargain upon things which are detrimental to you on a longer run, in a longer run. And you should, if possible, bargain as much as possible, till it is practically possible with the other party, right? So just because the other party is an MNC or a global company, it should not be like that I cannot say anything contrary to what they say in their agreement, because it is your right as the other commercial party to negotiate on terms and conditions, and you can do so as far as practically possible. And so far, so as you do not lose that client on 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 frivolous matters. So as far as it is important to you that you cannot compromise on such things, it is fine if you can let go of that client. But always keep in mind to bargain such terms and conditions in the first place. It should not be like that you do not even try to bargain the terms and conditions which are even detrimental to you in the longer run, just because the other party is a global company or an MNC. The next point is ineffective correspondences during a transaction, lack of recorded communication between parties, reserving the right to claim liquidated damages, etc. If any, lack of acknowledgement from the buyer regarding unequivocal acceptance, etc. So the ineffective correspondence, as I firstly stated also, that always we'll have to be adept with quick turnarounds in correspondences, and to record the each and every developments of the transaction, right? With the other party, so that it becomes easier for us to prove the transaction as it unfolded in reality, right? And there are no ifs and buts in proving such transactions, because it is already recorded. Everything is recorded because you were effective with the correspondences during that transaction. So if you are facing losses due to the delay on the other party's action, you must quickly record that communication with a mail, or a letter, saying that the this is the delay which is happening in the contract, and we are not responsible for the delay, and you are the sole responsible, you are the sole party which is responsible for such delay. And if you're facing any losses which can be attributed to the delay which was caused by the other party, you can provide the evidences for such loss in the mail itself, and say that I have reserved my right to claim this much of loss from you because of this delay. So all of these communication becomes very much effective, because at a later stage you cannot come up and say that you delayed at that point of time, and we faced this much of losses, so I'll have to deduct this much of, or I'll have to demand this much of extra money from you. So because at a later stage it becomes really unconvincing for an adjudicatory body, or a neutral body to actually accept that you never reserved your right, or you never even whispered about this loss when it was actually happening to you, to the other party, right? So all of these effective correspondences have to be kept in mind. And the last one is difficulty in realizing from payments, buyers, cash transactions, etc. So I've seen a lot of parties doing cash transactions conveniently, and whenever I say cash transactions conveniently, it normally happens to evade taxation liabilities, or 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 such related liabilities, right? But then cash transactions are equally difficult to prove, right? Because cash transactions do not have any trace to go back to, right? Because if you have taken any cash transaction, if you have undergone any cash transaction, it becomes difficult for both the parties to prove that this much cash was handed over to the other party unless the same was recorded in video, right? So please keep in mind that avoid cash transactions just to evade tax liabilities, because you may at that point of time evade tax liabilities, but if any dispute arises, you would not be able to prove that such transactions actually took place, right? Because as I stated, that there are no trace to trace the cash back to, right? So I'll move to the next slide now. The consequential effects due to the challenges. So the first is the lack of financial resources. Whenever delayed payments, the issues of delayed payments are faced by any of the enterprises, the first and the foremost challenges that they face is the lack of financial resources, because you have already invested, you incurred your expenses in carrying out such services, or producing such materials, right? Or manufacturing such materials. But when the payments of such materials, of such transactions, or such services gets delayed or stuck, then it is almost naturally it is almost natural to have lack of financial resources, because your expenses are not compensated uh, till now. So the liquidity crunch in the businesses is severely affected. So the first is obviously the lack of financial resources. The second is lost claims due to not having enough evidence, materials on record to prove default. As I already stated, that if you would not reserve your right at an appropriate stages of time, or if you do cash transactions to evade taxation liability, so that much of quantum, or that much of claim that you could have asked from the other party would not get included, or would not get proved, just because you didn't have any enough evidence. So all of those things uh, gets into gets materialized into these consequences, which are lost claims due to not having enough evidence and materials on record to prove default. The other one is claims being undervalued, right? So the claims being undervalued is nothing but, let's say that you supplied around 80 lakhs of material, but you only raised a bill for 40 lakhs of material, and for that quantum, half of the quantum of the lot, and half of the quantum of the lot you delivered, and took the cash, and took the payment in cash, just so to avoid that tax liability. So now let's say if your 80 lakhs of materials was was provided to the other party, and the other party has now disputed on all the lots, right? So now the whole of the lots, however, be it of 80 lakh of rupees, now only is claimed at 40 lakh of rupees, because you cannot go and say that I took 40 lakh of rupees in cash and just so to avoid taxes, right? So you are in a way undervaluing your claims in that situation, right? Because you cannot at a later stage go and say that just so to avoid and evade taxation, I I raise the bill just for the half of the amount, right? So it also undervalues your claims at a lot of situations, in a lot of situations. And the same is the loss of damages liquidated for breach of terms of the arrangement by the buyer, right? So as I stated that you have to reserve your right whenever the losses are happening, then you have to reserve such rights, that such losses are that my enterprises are facing such losses, and evidences might be provided of such losses, and you should reserve your right at that point of time, that yes, I face such losses and I reserve my right to claim these damages from you at the later stage of time. So all of these things get strengthened in a way when you do it in an effective communication, right? And if you do not do it effectively, it is almost natural to have losses of damages, right? And as I already stated, the next is liquidity crunch in the operation of businesses. So whenever the delayed payment arises, there is natural liquidity crunch in the operation of businesses. The last one is not able to realize the actual amount as reflected in the turnover generated by the MSMEs, hampering the expansion and growth of the businesses. So it is also natural that whenever you have supplied all the materials to the other party, so even if you have not received the payments, the invoices would be reflected in your turnover, right? So by paper, it would show that you are entering into large number of transaction, and you are handling large number of liquidity. But then in reality, you're hampering your expansion and growth of the enterprises would be hampered, because of the delayed payment and the issues of delayed payment, because in reality those payments have not still yet come to you, right? And the minimal profitability. So all of these issues, when if even if you receive your delayed payment at a later stage of time, it significantly reduces your profitability, right? Because you already faced a lot of losses just because it was not realized at a proper time. So at a lot of time, the profitability significantly reduces, and a lot of time it gives you zero profit, and a lot of time it actually makes loss to you rather than making any profit to you. So and coming to the next point is not taking proper and relevant professional consultations, resulting in losses. So I have seen a lot of time people going to adjudicate all of these disputes by themselves, or to handle these things all by themselves, even if their dispute entails a lot of complex professional uh, a lot of complex professional analysis, right? So I have seen people who have not approached, or who have not done anything till the limitation period of time, and they come to me at a later stage of time, after 10 years, after 12 years, saying that our payment was stuck from this buyer in 2010, 2011, and they have not still yet paid to me. And I've tried to reach out to them a lot of time, but they kept delaying it, and they did not do, and kept sleeping over their rights for 10 good years. So now they cannot come and, at per their own sweet convenience, say that now you go and recover my money for me, right? Because you have to be diligent, you have to be careful of your rights, right? Because if you're not diligent and you're not careful about your rights, if you not take professional consultations, it is very probable that you will miss out a lot on lost claims, lost damages, or loss of cases, even in certain circumstances. I do not mean to say that you cannot handle all these cases on your own, but then it is again a commercial wisdom to realize that not everything can be handled by everyone. So if your case is too much simple that you even by yourself eh, can understand and do not have any problems in the law side or in the transaction side of it, then it is fine that you go and you handle these things on your own. But then even if you think that you are doubtful in any of these things, if the other party has disputed your claim or has given you certain legal things that it is not as what you claim, then you should not only rely upon your own judgment if you're not a professional. So it is always preferred that you go and you consult a professional and then you proceed, because I've seen a lot of times that the clients are facing detrimental losses. They lost their claims, they lost their damages just because they were not diligent, or they did not consider this a good advice to go and to consult a professional for all of these things, right? So the second last is ineffective workforce due to lack and wastage of valuable resources. So as I stated, that the liquidity crunch is not solely for the enterprises, right? The liquidity crunch is for each and every unit of the enterprises. So all the workforces, all the managerial positions, all the executive positions in a company, all the machineries, all all of the units get affected whenever there is a liquidity crunch, and it leads to ineffectiveness of the operations of the enterprises, right? So it wastes a lot of valuable resources just because uh, there is liquidity crunch. Might be that the workers are not paid on time, or it it's still the dues of the workers have not been cleared. So it's quite natural for the workforce to get ineffective due to these consequential effects, right? And the last is the legal troubles due to ignorance or no knowledge of various industry specific mandatory compliances. So I have seen a lot of enterprises doing very big transactions, going and generating a lot of a lot of investment from outside, going and taking grants from outside, and they are not having proper documentation, and they are not having proper shareholders agreement whenever they are starting out a company, or they do not give enough importance to all of these documentations to begin with. Then at a later stage it is quite natural, and I've seen this firsthand to many of such companies or many of such enterprises who do not consider, or who do not consider these all of these things important, to at a later stage to detrimentally get affected by it, to have a detrimental effect on their business, because all of these, if sorted out at a very earlier stage, can be very much beneficial to any businesses, right? So for example, if I'm saying that if you're into any manufacturing of any food material, or any material which are for human consumption, then it is already known that you should comply with the FSSAI rules and regulations. So there are not one rules and regulations, there are various rules and regulations. So there are packaging requirements, there are there are requirements which prescribes the quality of the certain goods and nutrients, and the foreign materials, which the percent of foreign materials which are allowed under such food materials, right? So all of these things should be taken care of, right? Because ignorance of, or no knowledge of these legal provisions cannot become an excuse for you to get exempted at a later stage, right? Because I've seen a lot of businesses facing huge fines and huge legal troubles just because they ignored industry specific mandatory compliances, or they did not consider it important enough to have proper documentation of the enterprise to venture into the commercial transactions. So we'll move to the next slide now. Solutions and the way forward to overcome challenges. So the first is the preventive measures and solutions to be adopted internally in an enterprise. So as I already stated, to enter into a written agreement recording the understanding of terms between the parties, duly executed, properly stamped and notarized, work orders, purchase order to be raised under such agreement, work orders to be shared on an electronic medium too, even if a hard copy of the same is raised, recording each and every transaction in terms. So all of these in a nutshell becomes the preventive measures and solutions which you can adopt internally so as to avoid the issues of these delayed payments happening from the first hand, right? And even if it happens, with all of these preventive measures being in place, then let me assure you that your case of case reference of delayed payment or your issues of delayed payment would get instantly resolved, and there would be very much less possibility of you not succeeding in such legal proceedings, right? So all of these preventive measures should be kept in mind, that you should execute an agreement for every transaction which are large in nature, and you should raise work orders and purchase orders for every such work under those agreements, right? You should incorporate every important provisions, right? So the important provisions of unequivocal acceptance of work purchase orders if no defect, protest or demur has been pointed out by the buyer. So as I already stated, when you can include this in agreement that whenever you supply any goods to this buyer, so if he doesn't, or if the buyer doesn't in 30 days, or let's say 15 days, revert back to you pointing out any inconsistency or defect in such goods, then it would be understood that the supply of such materials is unequivocally accepted by the buyer, right? Because it cannot be open ended for a indefinite time, so that after 6 months also the buyer can say that the quality of the goods which were supplied to you were not as per the expectation. So all of these, the dispute resolution clause, whether you want your dispute to be resolved by litigation or arbitration, all of these things could be included in an agreement, or even to say in terms and conditions of a purchase order. So all of these things to be kept in mind, and all of these are preventive measures and solutions which you can adopt internally, sorry, in an enterprise, so as to avoid or to significantly reduce the possibilities of these issues happening in the first place. And the last one is, as I already stated, being adept with communication, reserving of right to claim damages if any, receiving acknowledgement of the due amount from the buyer. If you have any if you have any delayed payment from any buyer, then what you can do is, well, you can ask for any acknowledgement, unequivocal acknowledgement by the buyer, saying that yes, there is this much of due which I have to pay to you, and I'll pay this much of due in this much of time. So all of these acknowledgement, what they do is they extend the limitation period again. So so keep in mind to take this acknowledgement from time to time from the other party. And all of these communications, you must keep in mind that each and every development of the transaction, of any commercial transaction, should be recorded in a manner that it reflects that how the transaction unfolded in reality. So as to not make it difficult for any party to prove the transactions of how the transaction took place actually, and to ascertain the liability of the parties, right? So all of these things you can keep in mind, and you can adopt internally, so as to streamline your operations and to reduce the possibility of getting into these issues of delayed payment in the first place. Moving to the next slide. So, taking proper consultations, I would not go into the details of all of these pointers, because I've fairly dealt with all of these points in my earlier webinars also, and in today's webinars also. And so I would just read out all of these point by point, so for you to understand. So, taking proper consultations from relevant professionals, I have stated, to have a legal secretarial audit and verifying the industry specific mandatory requirements compliances under different statutes, incorporating effective ways to execute agreements, communications, follow-ups, receiving acknowledgement against purchase work orders, and delayed payments. To carefully assess damages clause in the agreement, computation of claims under various heads such as price escalation, overhead charges, machinery and workforce idlement charges, etc. So all of these loss of profit, loss of profitability, all of these things could be claimed, and these things should be analyzed and computed carefully, so as to not miss out on important claims, or miss out on any heads, right? Any heads of these components. To be well versed with all schemes, benefit policies by the government affecting MSMEs. So always keep in mind to be adept with all the knowledge that there is regarding MSMEs and their policies and schemes, right? So it becomes really beneficial for your business to know of the current policies, benefits, and schemes which are applicable to you. To safeguard the interest of the businesses, creating strategic assets, raising proper invoices with GSTI and UAN PAN, and be updated with statutory tax and other filings. So always be updated with your statutory tax and other filings. Mention these GSTI and UAN PAN on your invoices. Also mention your MSME uh, registration ID, UN, Udyam registration, and Udyam Aadhaar memorandum on your invoice if possible, and create strategic assets such as if you have any fashion label, or if you have any if you have any goodwill, then try getting a trademark registered, or if you have any website, or if you have any original art form, then then think of getting a copyright registered. Or if you have any invention or any scientific process which is original in its nature, then you can consider filing patents. And if you have any design which enhances the look of any product, then you can go for a design registration, right? So all of these are strategic assets that you can create uh, pertaining to your products. And if you want to also safeguard those assets and fashion labels and your goodwill in the outside, in the public, then you can create these strategic assets, and and streamline and make good of your business, right? So all of these things you can keep in mind. And all of these advices are generally for very small businesses, or businesses who are not getting these kind of consultations on a daily basis, right? Because I've seen a lot of businesses raising invoices without any proper details, which are statutorily required under the indirect taxes regime, or under our statutes, right? So all of these things have to be mentioned on your invoices, right? So all of these things you can keep in mind. To create outreach with online presence, I already stated. And the next one is being adept with follow-ups for payments. So always keep in mind that you must follow up for your payments, and if you're not getting a payment, get an acknowledgement instead. So it extends the credit period. So it extends the limitation period, I'm sorry. And the last one is acquiring a post-dated check for the bill raised as a security measure to avoid delayed payment. So we'll talk about this in detail, but what it is what this is that you take a post-dated check for that amount which you have raised as an invoice from the buyer as a security measure. So if it does not clear the invoice in a given timeline, what you can do is you can go and you can present the check to the bank, and you can encash that check of that buyer, so to secure your payment. And if that check gets bounced, then you have a recourse in law to take civil and criminal proceeding against the against the one who issued the check to you, right? So this might act as a security measure to you, to have a post dated check from the buyer, so to secure your payment, or to secure a legal proceeding against the buyer, if it does not if the buyer does not clear the payment in the given timeline. Coming to the next slide. Now we'll come to the external solutions. We have talked about the internal solutions in detail. Now we'll come to the external solutions, the resolution of dispute, litigation, and ADR. So I'll not harp on much on these pointers, because it are all of these are dealt in detail under my previous webinars. But I'll just give you an insight, a brief. I'll briefly touch upon all of these things so as to give you an understanding of how you should go about it, right? The recourses from MSCFC under MSMED Act. So there are recourses under MSMED Act for recovering delayed payment. There are recourses under Negotiable Instrument Act, which are in case of bouncing of checks or dishonor of checks. We'll discuss those. The third one is Insolvency and Bankruptcy Code, the recourses under IBC, and the fourth and the fifth and the sixth one is the fifth and the sixth one is civil suit and the summary suit, which are the classic way of litigating. And the last one is mutual resolution, which is nothing but resolving the disputes on your own without taking any assistance from anyone. And the both the parties mutually get into talks and amicably resolve their disputes by themselves. So it is mutual resolution, it is nothing more than that. So we'll discuss these recourses one by one. So firstly, if I'm not wrong, it must be MSME. So the section 7, as I already stated, is classification of MSMEs. The section 9, 10, 11, 12, 13, 14 is all of section 9 to 14 are the facilitation provisions, which are there for facilitating the MSMEs. And it includes measures for promotion and development of MSMEs, the credit facilities which can be extended to the MSMEs, the procurement preference policy. So if you'd see any government tender or any procurement tender issued by the government, it has a preference policy for the MSME. It gives a preference for the MSME bidders, right? So the section 11 covers that. The section 12 covers the funds which can be which which are which are for the MSMEs. The section 13 is grants by the central government, which are for the MSMEs. The section 14 is the administration and utilization of funds. So how the MSME ministry would be administered, how the bodies under the MSMED ministry would be administered, and how the utilization of funds would be. So all of these are dealt under section 9 to 14. And then section 15 onwards, section 15 comes the recourse for delayed payment. So section 15 says that the liability of buyer to make payments. It says that within 45 days after raising the invoice, the buyer has to make payments, and after 45 days the buyer does not make payments, the buyer would be in section 16. It is stated that the date from which and the rate at which interest is payable. So in 15 it states that the 45 days you have to make payment. In section 16 states that after 45 days the interest rate would be applicable. The interest rate would be three times the interest rate notified by the RPI for this purposes. Section 18 states the reference. No, yeah, section 18 states the reference to MSCFC. That section 18, under section 18, you can file reference application to MSCFC whenever there is a issues of delayed payment. Section 19 is application for setting aside decree, award, or order. That is, whenever you have an award, you got in an award from MSCFC saying that you have to take this much of amount from the buyer, and the buyer has to pay you this much of amount. And if, let's say, the buyer has to challenge that decree or that award, then the buyer in section 19 can make that application for challenging those awards which is passed not in his favor, right? So and for doing such thing, he'll have to mandatorily deposit 75% of the amount which is given under the award. So to make an application under section 19, and to maintain that application under section 19. So it is there as a measure to remove all the frivolous litigation. So it is almost natural for all the buyers to come and to challenge all the awards that are against them, right? So it does not, so that it does not happen, the section 19 is inserted, because anyway you'll have to deposit 75% of the amount anyway before you challenge such award in section 19. So only such awards are challenged which are genuine for the buyer to be challenged, right? So many a times I have seen, whenever buyer receives such an amount that he has to pay this much of amount to any supplier, then generally after receiving such an award, they do not go for challenging those awards, because anyway they'll have to deposit 75% of that amount. They generally approach the supplier, and they generally settle the payment, and it is not generally challenged, because of this section, because it makes mandatory for the buyer to deposit 75% of the amount which is been passed in the award. And the section 24 is overriding effect. So the section 24 gives the MSMED Act preference over all the other acts which were passed before it. So the any delayed payment issues, or any jurisdictional issues, the MSMED Act would have overriding effect. So any inconsistency in two clauses between the two acts, so the MSMED Act would have overriding effect, because it has an overriding notwithstanding clause. It is stated in law in section 24, which gives the MSMED Act an overriding effect over all the other acts at the time being, right? So coming to the other slide is section 11, is slide 11, the recourse after dishonoring of checks under negotiable instrument act. So as I stated, that you can have a post dated check for the amount, for the same amount which is raised in your invoice. So to secure your amount, if it is not get paid in the prescribed timeline, you can go and you can present that to the banker of the buyer. And if you get your payment, then well and good. And if the check gets dishonored, then under section 30 138 deals with such checks, whenever the checks gets dishonored for the reasons of insufficient funds in the account. And in section 39, the presumption is always in the favor of the check holder. So whoever is holding the check, the presumption is in their favor, that they are holding the check in furtherance of discharging of the liability by the buyer. So the buyer, in furtherance to discharge his liability, has given this check. It is always the presumption in section 139. So the presumption is always in the favor of the check holder. Section 142 gives the cognizance of the offences. Who can take cognizance? The cognizance can be taken by the metropolitan magistrate or the judicial magistrate first class. The procedure is, you have to send a notice to the other party, and give him a time for 30 days to make the payment. And if such payment is not made within 30 days, you can file this complaint before the magistrate. And you can have civil and criminal action both simultaneously for dishonoring of checks. And action can be, if a check is given in the name of an enterprise, then action can be taken both against both the enterprise and the signatory of the dishonored check. So the director who has signed the check would also be liable under these proceedings, even if the check is in the enterprise's name. So this has to be kept in mind. Now, slide 12 is recourses under insolvency and bankruptcy codes. So always keep in mind that all of the manufacturers or service providers are operational creditors under the IBC, right? Insolvency and Bankruptcy Code 2016. So IBC is not a recovery mechanism, so to speak, but it is seldomly used as to recover money, because it creates pressure on the company to clear the payment, or otherwise they'll have to go into CARP, which is Corporate Insolvency Resolution Process. So they'll have to enter into insolvency. So if at any time your quantum of debt, or if your quantum of dues is exceeding 1 crore of rupees, then you can always move to National Company Law Tribunal if your buyer is an LLP or a company. So if your buyer is a LLP or a company, the other party, the opposite party from whom you have to take payments from, is a company or LLP, then only IBC gets attracted. If it's a trust, if it's a society, then the IBC proceedings would not get attracted. IBC would not be applicable. So it is only applicable in cases of companies and LLPs. So Always keep this in mind. The other qualifying condition is your debt should be of 1 crore of rupees or more than 1 crore of rupees, and your debt should be already ascertained. Your debt should not be disputed. So if your debt is disputed or if it is not ascertained, so any party cannot say that okay, 1 crore of rupees is due. And the other party and if you say that, I'm sorry, if you say that 1 crore of rupees is due and the opposite party states that no, not 1 crore of rupees, but only 50 lakhs of rupees is due, and by the documents and by the evidences that you have relied upon, it cannot be ascertained that yes, 1 crore rupees is due, then just because your default is disputed, the IBC is not get IBC does not get attracted, right? So always keep in mind that your debt has to be crystallized. It has to be, it is already proved or it is already crystallized. There are no scope of creating dispute that okay, this is not much, this dispute is not of what the creditor is claiming to be. So let's say if you have approached the NCLT saying that I have to take 5 crore of rupees from this buyer, and the buyer has disputed the amount, then then the jurisdiction of the NCLT would not get attracted, because the dispute and the debt has to be crystallized. They have to ascertain that yes, this much of amount is at least due, and it must be at least, it must be at least proved from the evidences that you have relied upon. So what it does is it takes away the right of the board of the directors from a company, and it suspends the board of director of the company permanently. It takes the company out of their purview, and it is given to to, to an interim resolution professional to run. Now the interim resolution professional, what he does is he asks all the creditors of the company that you all please submit your claims to me, and I'll see that okay, this much of claims is due to you. And after all the creditors have submitted their claims to the IRP, he collates all the claim, he collates all the assets of the company, and he takes out an information memorandum detailing out all the liabilities of the company, all the dues of the company, all the claimants of the company, all the assets of the company which company possess, all the monies that the company has, and it details it out in an information memorandum, and it gets floated in the market. The other companies in the market can come and can give an offer to a committee of creditor. The committee of creditor is a committee which comprises of financial creditors. Now, if you remember, I stated that all of the creditors which are generally under service providers or manufacturer of goods are operational creditors. So you'll not be the member of committee of creditors. So you'll not be the one who decides. So all the companies who are outside the market offers the committee of creditors that this is the offer that I am giving to buy off the company, and I will settle all the claimants account in this manner, and I'll take the company from now on. So if the committee of creditors finds good in the offer, they accepts the offer, and the company is sold to the other party as a going concern. And as per the resolution plan, the plan that they submitted, the offer they submitted, with which they were gonna buy the company, they were gonna settle the accounts of the claimants. In the same manner, the accounts of the claimants get settled. So this is the nutshell in how the proceedings under the IBC runs. And if no one makes any offer for the company, or committee of creditor does not agree with any of the offers made to it, then if the CIRP fails, the insolvency resolution professional process fails, then the company goes into liquidation process. All the assets of the companies are sold, and which are distributed in a pro rata basis, which are given under section 53 of the IBC. So all of these things are important. You also have to keep in mind that you can only recover this money from the corporate debtor till the time the company is not into insolvency. So you can only create a pressure and to get a payment from the opposite party, right? Because being an operational creditor, if you initiate insolvency of the other party, then being an operational creditor, you'll also have to deposit 1.5 lakh of rupees as a preliminary CIRP fees, which you'll have to borne by yourself, which you'll have to submit by yourself to the NCLT for the CIRP to go on. and then you'll also not be a member of the committee of creditors, so you'll not get to decide so which offer to accept, right? So a lot of times, if operational creditor had around 1 crore or 5 crores of dues from the corporate debtor, I've seen the operational creditors many a times not getting any rupees, or getting zero, nil amount, just because as per the waterfall mechanism, or as per the offer made under the resolution plan and accepted under the committee of creditor, there are no payments to be done to the operational creditors, right? So this is a very tricky situation. Always think this through before proceeding under the IBC being an operational creditor, right? So I'll move to the next slide. The resolution by way of ADR, that is arbitration and conciliation. So I'll again repeat that the process under the MSCFC, for the process under the section 18 of MSMED Act, under which you make reference application to MSCFC in order to adjudicate your issues of delayed payment, it is also governed by Arbitration and Conciliation Act. And Arbitration and Conciliation Act also governs arbitration in a general scenario. So arbitration is nothing that but you appoint a neutral party to adjudicate the claims or adjudicate the disputes which have arisen between the parties to the contract. And now the parties would submit a statement of claim detailing out their claims from the opposite party. The opposite party would submit a statement of defense stating that the defense that they have, or the reasons why they feel that they should not pay such claimed amount, or if they have any counterclaim, they can also file the counterclaim. Then you'll have to adduce evidences, then you'll have to give arguments, and basing on all of those things, the arbitrator passes an award. Now, after passing an award, you have to take an award. It has the same force as a civil court decree. You just need to enforce it now, and you'll have to execute it for the realization of the money, right? So I'll not go into the detail, because I'd suggest you to refer to my earlier webinars for if you want to get into the legal details of all these provisions, because I do not think that it would be very much beneficial for you to get into the legal details of all of these provisions, because it will take a lot of time. So to make you understand all the legal intricacies that are there in all of these sections, right? So just for your understanding, if there is an arbitration clause in the agreement, then you can always invoke arbitration and conciliation, and it would be governed by the Arbitration and Conciliation Act only. And you'll have to always invoke arbitration and to move under arbitration to get your dispute resolved. Not to say that if you are also an MSME and there was an alternate uh, independent arbitration clause in agreement also, in that situation, it is not bar for you to approach MSME, because both the proceedings are governed by arbitration only, right? So even if you have an independent arbitration clause, you can go to MSME for your resolution of disputes, but you cannot go to anywhere else. And if you're not going into arbitration, then there is virtually no recourse for you anywhere else, but you'll have to go for arbitration if there is an arbitration clause agreed between the parties, so to resolve their dispute, if the dispute is arbitrable. Now, it is also like that, all of the disputes is not arbitrable. The taxation disputes are not arbitrable. A lot of time the rent uh, disputes are not arbitrable, and all of these disputes are not arbitrable in nature. So these disputes cannot be arbitrated. But all the disputes which can be arbitrated, and if there is an arbitration clause there, you have no recourse but to go into arbitration for resolution of your disputes. Now I'll come to the more classical way, that is civil suit for recovery. It is nothing but you institute a suit for recovery of money. You can also go for summary suits. Summary suits are a special kind of suits where you have enough evidences and you file your suits with enough evidences saying that the opposite party should not be given any chance to defend, because he does not have virtually any defense available to it. And then the opposite party would given a chance to convince the judge that why he should be given the opportunity to defend this case. And if he is able to convince, then your summary suit gets converted into the normal suit. And if he is not able to convince, then without his defense and basing on your evidence alone, your summary suit would be decided. So it is a special way of instituting suits, that is summary suits, and it can only be done in a clear cut case, in an open and shut case where you have all the evidences and the opposite party virtually have no defense available to it. So all of these are governed under the civil procedure code. And in if all of these disputes surpasses a pecuniary limit of 3 lakh of rupees, then it goes under the newly made Commercial Codes Act. It reflects, and it is same as the civil procedure code. It is just for the commercial suits and the commercial disputes which are classified from normal civil disputes, right? So all of the things are same in summary suits, in CPC and the corresponding sections of the Commercial Codes Act. However the sections are not same, but the whole idea of codifying the procedure of dealing with commercial suits or civil suits have been kept same. So always keep in mind that if you do not have an arbitration clause, and if you do not have any suggestion in your agreement or your work order or your purchase order, then and if any dispute have already arisen, then you can always approach civil courts or commercial courts, as the case may be, to resolve your disputes, right? Now, the quick tips and suggestions: always mention applicable GSTIN, UN, PAN numbers on invoice, as I already stated. Invoices communications has to be recorded, managed, online way of communication. Always communicate, as I already stated, that communication is really important, and communication at appropriate time is important. So be adept with your communication, be quick with the turnarounds, and then it is always have a pre-estimate of an amount which can be claimed as damages in case of delayed payments. So always have a pre-estimate amount incorporated in an agreement that the both parties sign. And you can show that this is a genuine pre-estimate, and this has been agreed between the parties. So it becomes easier for you to claim the same amount, and not prove all those losses as you had to otherwise. And always try to settle amicably, as I already stated, that the mutual resolution is always the best. If the parties sit together and resolve the disputes amicably, then it is the best way to do so. And the last one is always try to safeguard interest by registering trademarks, design, mandatory compliances, and update statutory filings. So with all of this, I'll end the webinar for today, and I'll take your questions and answers now.
Thank you so much. It was a wonderful session, and I request all the participants for what all questions you have, you can raise your hands and they'll be
I can
answered. And
see
sir
some
will be,
questions and answers
yeah,
category.
yeah. In the
Uh,
chats also they have some questions. So, sir,
okay,
please.
so we'll take it one by one. You can call them up one by one.
Yeah, yeah,
I'll
sure.
take the questions.
Mr. Kandikar ji, can you unmute him, Karthik? Mr. Kandikar wants to ask the question. Welcome, sir.
Good
Please
evening,
ask your question.
Good evening. Good
Very
evening,
good
sir.
evening.
sir. I am a service provider company, and I had rendered some services to a government department, Delhi Transco Limited, to be specific. So after raising the invoice, I was not paid the amount for 24 months.
Okay.
I repeated follow-up with the department, did not yield any positive response, nor there was any issues raised with my invoice. But the amount was not paid to me, so I had to take recourse to MSEFC, and the case was
It must
heard.
be referred to DAC then.
Actually, I had applied to that portal is there, public grievance portal.
Hmm.
Through that, it was dealt with by Delhi East,
Yeah.
EFC,
Yeah.
and I ultimately got the payment after 24 months, after
Okay.
so many deductions and all, which I agreed, of course, because they showed some contract terms, so I had no option but to agree to those.
Okay.
I got the payment, but now my issue is that the delay which has taken place of 24 months without giving any reason for holding the payment. So I want to fight it out for the interest part. Is it possible for me to file a claim for interest?
Yeah. So in your award, you did not get the interest component, sir?
No, award was actually I did not fight for the interest in the first place. I fought only for the release of payment because the department was not responsive. They were not answering any emails. They were not answering any phone calls. And only reply which I got, indirect replies I got, was that it is under process and there are some procedural difficulties at our
So,
end.
sir, legally speaking, you can go for the singular component, which is interest component, and
Yes.
I'll suggest that you send me across your documents first, because this is a peculiar case. I'll have to look to the documents first. I'll have to
Okay.
see the award first, and I have to see the settlement that you parties reached to, so as to advise you in a better manner. But
There is no.
legally speaking, if you have not waived off your claim of interest, then you can always claim your interest on delayed payment separately. It is not an issue, and you can file a reference also in
Hmm.
MSEFC just for the interest component.
No, I have not filed for interest because there was no. I was not getting the
No,
main
no, no,
payment for
not
interest.
at that time. Now also you can file.
Now you can file. Now I can
Huh,
file.
it, it
Okay.
it just had it just has to be under limitation. So I should ask you that it is not barred by limitation, right? Because uh so you cannot ask for the delayed interest part after 3 years from last cause
Payment.
of action.
Okay. So I got the payment in August. So I can
August
still
of
claim the
2023 itself.
23. Yes.
Yeah. Then you are completely under limitation. You have no concern at all.
I
Then
had
you
raised
can yeah.
I had
Then you
raised
can
the issue with the MSEFC in December 22.
Okay, okay. So I'll just look at the award first, sir, because MSEFC should not have given you just the payment. If they received that this much of payment is delayed, then they should have given the interest component because it is in the statute itself. They cannot be like, "Okay, I'll give you the payment, but I'll not give you the interest." Because it is there in the statute itself. It is your right to receive the payment. So I'll have to see, I'll have to assess that whether you should go for challenging the award because the interest is not given, it should have been given, or you should go for interest again, for demanding interest again. So I'll have to assess these two options, and I'll have to advise you accordingly, sir. So for that, I'll have to look at the documents.
And there is one more case.
Yeah.
Should I send you the correspondence and whatever has happened in
Sure,
the
sure,
case so
sir.
far?
Sure, sure. That way,
Okay.
that way, it would be very much easier for me to look at the correspondences first, and then we can get on a call. Megha
Okay.
would connect us, and we'll talk it out.
Okay. And in there is another case in which
Yeah.
there was a contract which was valid for 6 months. A
Okay.
certain quantity of it was a item rate tender in
Mhm.
which certain quantities were to be executed over a period of 6 months.
Okay.
And all these for executing all these quantities, a shutdown was required from the government to
Okay.
execute because it's an electrical installation.
Sure.
Unless there is a proper intimation of the shutdown and all, the
Sure.
work cannot be done.
Sure.
So in the 6 months, uh, practically nothing was done because they could not really shut down.
Okay.
Uh, Then they asked me to extend the contract validity period. So I extended by another 6 months.
Okay. Okay.
So in this extended 6 months, the quantity executed was only 35%.
Okay.
So they paid me 35% after 24 months of my raising the invoice.
Okay. Got your point,
Uh,
sir. Got
okay.
you.
And
Got you.
now there was a clause in the purchase order which says that the quantity variation could be maximum in the range -80 to plus 125%. That is to say that the quantities cannot be reduced by more than 20%.
Yeah, I got it. But
Okay.
they have only taken 35% of the work from
Yes,
you.
yes. So now executing at the prices committed only 35% of
You
the
can claim
scope.
for the loss of profit for the shortfall of the percentage.
I
because
can claim
because
now.
yeah, you can claim, sir. You can claim. If
Sir, it
there
will
there
be
are two
very
types of loss of profit which you can claim. One is loss of profit on uh delayed contract, where you could have gone to somewhere else and you could have done
correct,
some other
correct,
work. That is
correct.
one loss of profit.
Yeah.
And the one loss of profit is on illegal termination. Or let's say, when you were given 2 crores worth of value of
Mm,
work to be done,
mm,
but the contractor did not avail that 2 crore of rupees, and you
yeah.
were only given 50 lakh of rupees to
Yeah.
50 lakh of rupees to worth of work, then there
Okay.
is a 1.5 crore of shortfall that you are
Yeah.
facing. And
Yeah.
any profit, any commercial entity enters into any commercial arrangement for a profit, right?
Mm,
So
mm,
courts in a lot of cases have agreed to a 10% of profit minimal, that
mm,
at least 10% of profit, at least all the commercial arrangement anticipates in any commercial arrangement. So if they are not given you that much of amount, the
yeah.
10% of one, let's say 2 crores of amount they
Correct.
were had
Correct.
they had to give. So
Yeah.
10% of that was your profit. But
Okay.
now you have only done work of 50 lakh of worth. Now,
Yeah.
so the shortfall you can
Mm.
always claim as loss of profit.
Okay. Okay.
Yeah,
Uh, okay. Uh, so I will be sending all the correspondence to you, and I
sure.
would like to because this contract was a very typical contract. It was to be executed in 6 months, and the items which it required for execution were all imported items. And I had procured, the quantity of material to complete almost 100% of the work. And because the contract was not executed properly and not executed to the full extent of 80% at least, I lost a lot of money in procuring the items which are lying
Don't worry,
unused.
Kandikar ji. Whatever
Sure, sure.
issue you have, he will look into it just
Okay,
after the session and probably will get back to you as early
okay,
as
I'll send.
possible.
I'll send. Thank you
Thank
so
you.
much. Thank you.
And
I'll
I
await your
request other
I'll await your
participants
documents.
also.
Yeah,
Sorry, Prateek ji.
yeah.
I would request other participants also who have same issue regarding the delayed payment. We have
Okay.
uploaded form in the chat. You can just fill
Yeah.
those form and just after the session, we'll get back to you. Prateek
Okay.
ji will
Thank you, sir.
contact. Yeah. Thank
Okay.
you. Thank
Thank you.
you.
Thank you.
Thank you.
Okay.
Thank you, sir. Thank you.
Can we have other participant, please? Sneha ji, please unmute Sneha ji.
Hi, Sneha.
Hello. Hi, sir. So my
Hi.
question was that we are in service industry and we have the overseas clients also. So
Okay.
does MSME helps us in recovering the amount in for overseas client?
That I'll have to check. It's kind of tricky, Sneha, because the practicality of it is tricky. So in law, yes, there are ways in which you can take legal actions against foreign parties. That is
Okay.
fine. That is there. But in practicality, it becomes really difficult for the parties to do so,
Because
because
the laws over there in that country. That
yeah,
also
because
must be
because you'll
right.
have to get in touch with the embassies, and you'll have to undertake a lot of practical difficulties in realizing such amounts, because then the jurisdiction issues is there, right? Because the courts cannot
Okay.
from here issues summons or notices to the parties residing in any foreign jurisdiction. So that way it becomes a bit tricky. But if you give me some time, you can get in touch with Megha. If you'll give me some time, I can read upon it and I'll come back to you, because overseas clients have not
That's
dealt
right.
with that much, and
Mm,
because of practicality issues again. But I'll
mm.
help you out. It's not to say that I won't help you.
Sure.
I'll go through your documents, and I'll see the peculiar case, that what it is and what are the contracts and arrangement between you and the other party. The other party
Correct.
has any associate office in India?
I think no.
No. Okay. So what you can do is you can connect with Megha and you can connect with me then, and I'll have to ask a bit of time from you. So to go through this and come back to you.
Yes, sir. So where is your office located? Means,
In New Delhi, in New Delhi and Patna,
o-
both the
okay,
places.
sure, sure, no problem. We can access through mails or we can have a call. I can share
Sure,
you
sure,
the
sure,
document for the
sure.
relevant client and party, our contracts which are between us, because there is a
Exactly. All the
stipulated,
relevant documents that you have,
yeah,
any contract which was there between you and the
correct,
other
correct.
party,
There is
the
a payment follow-up
correspondences,
also.
the work order, and the invoices. That's all.
Correct, correct. I will share with you.
Yeah, sure.
Thank you, Snehaji. Can we have another participant, Mr. RFG? Can you unmute? RFG, please.
Hi,
Yeah,
Arifji. Hi.
yeah. Good evening, sir.
Hi, Arifji. Hi.
Sir, actually, we are freight forwarder company providing the container for the export business. In
Okay.
last year, to 2022, we had provided three containers to our one export house.
Okay.
Container was sold in the good condition from here before the war
Okay.
started.
Okay.
Suddenly, it has been started, and the European Union has put the force measure, and container
Okay.
was bring back the shipping line at the Mundra
Sure.
port.
Sure.
As per the shipper, they had provided us container, laden container to deliver at the Russia. But due to
Okay.
the force measure, the container was bring back in the India by the shipping line. They were helpless.
Okay.
Now that exporter is not paying me 47 lakh rupees, and
Okay.
actually he had to file one case, that criminal case, in the
Okay.
Mundra court, and Mundra court has denied to take the case, giving the reason that this is not a criminal case and intention is unlawful by the exporter.
Okay. Okay.
So
Okay.
what can I do in this matter?
This is again a very peculiar case, I'll have to say, because all of these cases, Arif ji, you cannot advise on just your what you're giving me. The idea is very little for me to advise you upon, right? Because it involves exporters, the other parties of different jurisdictions, and I'll have to see the documents that you had, the force majeure clause that you are referring to, the European Union, the applicable document that you are referring to. After that, I have gone through these documents, I would be in a better position for you to for to advise you in an effective manner, Arifji, because these issues are not general issues that I am dealing with, right? Because general issues are some contractor facing delayed payments, stuck payments from government departments or some MNCs or some global departments. So not all of or not many of the stuck payments or delayed payments happen from exporters and importers transactions, right? So there are there if your amount was not guaranteed by a bank which is there, import guarantee bank, if I'm not wrong, ECBC.
Actually, let me brief. Actually, we are taking container from the shipping line and providing container to the forwarder. We are a mediator, one
Hmm.
type of mediator. The exporter is siting in the India.
Okay.
So when we bring the container to the factory premises, they stuff the container handed over to us. We are handing over to the shipping line at the port
Okay.
premises, and they
Okay.
are exporting that container.
Okay.
And in this case, exporter has claimed the GST amount. Whatever I issued the invoice in 2022
Hmm.
April,
Hmm.
they have claimed the GST amount. They have taken the ITC also.
Okay. 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 So you're saying that they have availed the ITC, but they are not making payments to you.
Yeah.
So have you sent them a legal notice saying that you cannot raise all of these or you cannot withheld my amount because you have in a way accepted the transaction, have taken ITC, and you have virtually no defense available now. So to withhold our amount.
No, sir. Actually, what happened at that time, he assured me that you are innocent. Shipping line is bring back the container, so I will pay your amount, and I will file the case against the shipping line. They had filed. I was the witness. They have put me as a witness. I given my statement, and the court has denied to file the case, giving the reason that due to force measure and Russian embargo, this case is no more applicable in this situation. And
Okay, 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 okay.
till today, they are assuring me that I will pay you, but he is not giving a firm confirmation that
So
when
give
he
me
will
the
pay.
port authority's decision. So we'll have to challenge that
Okay,
because now the port authority is saying that they cannot take this case forward because of the force majeure and the embargo, right?
yeah, sir.
Yeah. So give me that port authority's decision where they have said it to you or within letter they have given it to you, must have given it to you, right?
Sure, sir.
So just share it with me, and then I'll go through the port authorities' decision, what they are referring to, what they are saying, why they are not taking it forward, and then I'll advise you that how you can challenge this forward.
Okay, sir.
Yeah,
Thank you very
yeah.
much.
Thank you, RFG.
Madhuji, please unmute Madhuji. Karthik, unmute Madhuji. Please unmute Madhuji, Shraddhaji. Karthik, is there a problem?
Hello. I'm sorry, there was a problem with my microphone. Am I audible?
Sure.
Yeah,
Yes,
you're on.
yes.
So my question is, so we are also SME, small enterprises, and we are having a list of customer who have not paid more than, it's been a more than 45 days, they have not paid us, as well as they have moved out. So after sending legal notice also, they are not responding for a call, even a email. We don't know what to do in that case. And there is a like lakhs of money which is, lying to from with the customers. So how can you we deal this kind of situation?
So now it's a bit tricky, Madhu. I must say you because I must say to you because if your delay is just only of 45 days, because this is some issues with MSME department. I do not know what they have not opened their portal for the cases or the invoices which are not paid and which are dated post August 2022. So if any of your invoice which is dated after August 2022 and if it is not paid, you cannot go with that invoice to MSEFC to register your case still because they are not accepting it. They are not accepting any case which are post August 2022 invoices. So only the invoices which are prior of August 2022 are taken for the reference or a filing of the reference. So if there is any arbitration clause, you can invoke the arbitration, Madhu, but then you do not have virtually any recourse but to write to MSME department and to tell them that there is no reason for you to not to accept the invoices after August 2022, and please start accepting the cases after August 2022. Even if they do not reply to that letter, then you can do is you can move to a writ petition in a high court. That is the only recourse, that is the only way out, because if your invoices which is not paid is of later than August 2022, you cannot take it to MSEFC as of yet. You'll
Oh,
have to see if there is an arbitration clause or if there is not an arbitration clause, then you'll have to uh, just go for civil suit or commercial suit.
Other than that, no other option. Like,
No, you'll have to wait till MSME opens their portal for the invoices which are later than August 2022.
so any estimates of opening it in coming months?
I have no idea. I
No
have
idea.
seen this happening for last 2 3 months. It makes no sense, but I do not know why they are doing it. The only reason might be that they want to wind up the cases which are of August 2022, prior of August 2022 first, and then they'll move to the later stage. But then this is only a mere speculation from my side, and it does not have any substantiation.
Okay, thank you so much for your input.
Thank you, Madhu.
Ji, Shraddha ji, please ask your question. Can you unmute Shraddha?
Hello.
Hi, Shraddha.
Yeah, this is Mayank.
Hi, Mayank.
Yeah, so we are working for Baba Atomic Research Center in Trombin and in Tarapur.
Okay,
So as per our contract terms, we should receive the payment in 10 working days, but we are getting payment in 3 months and in 4 months.
okay,
We are regularly following up with them for the payment and with accounts also of BRC. So there are some transfers that is going on, new accountant has come, so we are trying to following up with them, but we are not getting a proper answer with engineer, even with accounts.
got your question, Shraddha. Got your question, Mayank. Sorry. So what you can do, Mayank, is you can write in mail to BARC or the other party with whom you are working, and you can compute all the delays that they have caused in making you the payment till now, and you can compute the interest part of it. You compute all the delay in all the invoices, you compute the interest applicable, you add all those interest in all the invoices, and you say that this much of interest has been applicable on you on your delayed payment of this much invoice by this date, and I reserve my right to claim this interest amount from you at a later stage of time. So that is all you have to do, and at a later stage of time you can go and you can claim this interest amount as per MSME Act if you are an MSME.
Yeah, we are into MSME. So like what will be the interest rate for
So
the
I'll 6.5 into 3 would be the interest rate, if I'm not wrong. I'll confirm it to you, but the last I checked it was 6.5,
okay, done.
compounded monthly.
Understood.
Yeah,
Okay, thank you.
thank you.
Ji, Mahendra ji, please ask your question. Can you unmute Mahendra ji, please? Rohit ji, please ask.
Yeah, good evening.
Good evening,
Hi,
Rohit.
good
Good
evening.
evening.
Yeah, sir, I just wanted to know that whether it is compulsory for all the large entities, government organizations to pay MSMEs within 45 days?
Yes, there are a lot of advisories that they come out with,
Mm-hmm.
and the ministry has been really vocal about this. If you remember or not, because I have seen Nirmala Sitharaman being very vocal about this, that the government agencies cannot delay or berate the payments of MSMEs, especially MSMEs beyond the limit or beyond any reason. So she does not mention 45 days, but you can it is almost natural because the law provides for 45 days, so it's natural that she's saying in prescribed timeline, so it means 45 days. So
And if they are
yeah,
giving PO purchase orders stating 90 days payment terms, in that
90
case,
day payment terms to MSMEs also,
yeah,
and you're a government department.
no, we are MSME.
You are an MSME.
Yeah, we are working with large corporates and government entities. So if they are giving POs, suppose corporate entities are giving us purchase orders stating 90 days.
Okay. No, so
Yeah.
you can negotiate with them. You just
Okay.
provide them with your MSME certificates. Tell them that
Okay.
it is 45 days mandatory in law, and you
Okay.
have to make it in 45 days.
Okay.
They cannot deny it on it.
Okay.
If it
Okay.
is a government department, they would not deny.
Okay, sir. And one more question I have. What is the authenticity of WhatsApp email reminders? Are they does that hold good in the court of law?
It depends.
Okay.
But it is fine if it is if they are not communicating on email. Make
Hmm.
sure that you send it across on WhatsApp.
Okay. Okay.
Ha.
Thank you.
And do not take the screenshot by saving the name. So
Okay.
delete the name which is saved, and
Hmm.
the number should come so that
Number.
it yeah so that the other party cannot deny that it is not my number.
Okay. Okay, sir. Thank you.
Thank you, Rohit.
Hello,
Hi, Mahendra.
hello,
Hello, hi.
hello.
Hi.
Yeah, can you speak Hindi?
हाँ हाँ हाँ, बिल्कुल बिल्कुल सॉरी महेंद्र जी.
Yeah, you tell. Okay.
हेलो, हमने एक पार्टी को मटेरियल सप्लाई किया है,
जी जी
उसका पीओ भी है हमारे पास में,
जी बिल्कुल
और 2 साल हो गया है ऑलमोस्ट.
जी.
तो पार्टी पेमेंट नहीं कर रही है.
अच्छा जी.
जो किया है थोड़ा बहुत, बाकी मेरा
पार्ट
बाकी है.
पेमेंट किया है, आधा किया आधा नहीं किया है.
हाँ.
अच्छा अच्छा. कुछ बोला है कि आपके सामान में दिक्कत थी या फिर कोई
नहीं,
दिक्कत
कुछ
है?
नहीं है, वो नहीं है.
ऐसा कुछ नहीं है.
नहीं.
और आपका एमएसएमई में रजिस्टर्ड है
है, रजिस्टर्ड है.
एंटरप्राइज?
हाँ, रजिस्टर्ड है.
और जब आपने इनवॉइस रेज किया था उससे पहले से रजिस्टर्ड है?
हाँ, उससे पहले से.
तो आप एमएसएमई में केस फाइल कर दीजिए सर.
कहाँ पर करना पड़ेगा हमें?
ये ऑनलाइन फाइल होता है. ये मेघा आपको बता देंगी, हम लोग भी करते हैं.
ओके.
और आपका एंटरप्राइज कहाँ का है सर?
हमारा है कड़ी में, अहमदाबाद.
अहमदाबाद में है. तो एमएससीएफसी अहमदाबाद में आपका केस जाएगा. ऐसे फाइल तो ऑनलाइन ही हो जाता है एमएसएमई
अच्छा,
के साइट पे. आपको बस इनवॉइस देना होता है मुझको, और वर्क ऑर्डर देना होगा मुझको, और
बराबर.
डिटेल्स देना होता है ऑपोजिट पार्टी का और अपना. तो वो
ओके.
मैं आपको बता दूंगा कि क्या क्या डिटेल्स लगता है, और फिर आप बस वहां पे ऑनलाइन जाके आप फाइल कर सकते हैं.
ठीक है.
हाँ, और जैसे ही आप फाइल करते हैं, मैं आपको पूरा प्रोसेस बता ही देता हूँ कि क्या होता है उसके बाद. कि आप
ओके.
फाइल करते हैं केस, उसके बाद आपका केस फाइल होगा. उसके बाद
हम्म.
जो डॉक्यूमेंट्स आपने दिए हैं अपने
हम्म.
केस के साथ फाइल करने के लिए, वो एक
हाँ,
बार वो लोग प्रिलिमिनरी चेक करते हैं. मतलब उसको शुरुआत में थोड़ा सा चेक करेंगे कि वो सही
बराबर.
है या नहीं, इनवॉइस जो है आपके रजिस्ट्रेशन का बात का है या नहीं. उनको सब सही लगा तो वो एक नोटिस दे देते हैं ऑपोजिट पार्टी को, जो दूसरी पार्टी है, कि
हाँ.
आपके खिलाफ केस आया है, इतना पेमेंट मांग रहे हैं ये, और
हम्म.
आपको इतना पेमेंट करना है इनको 30 दिन में, नहीं तो आपको एक जवाब देना होगा कि क्यों नहीं करना है आपको पेमेंट. तो
हाँ,
जो
बराबर.
अदर पार्टी है वो आपको या तो पेमेंट कर देगी, नहीं तो एक जवाब देगी कि
हम्म.
मुझको इसलिए नहीं करना है. तो जब वो आपको जवाब देगी एमएसएमई को कि मुझको इस तो नहीं करना है मेरे हिसाब से, तो आपको फिर
हम्म.
से जवाब देना होगा कि नहीं जी, मेरा हिसाब से तो उनको
लेना
करना
ही
है.
है, बाकी
हाँ,
है.
तो आपको उनको ये कहना होगा कि आप इसको प्रोसीडिंग्स में बदल दीजिए, केस रेफरेंस में बदल दीजिए. तो केस
बराबर.
रेफरेंस, तो जो आपका रेफरेंस केस है वो केस में बदल जाता है. तो जब
हम्म.
वो केस में बदल जाता है तो पहले कंसिलिएशन होता है. दोनों पार्टीज को बुलाया जाएगा, और दोनों पार्टीज को डिसाइड किया जाएगा एक न्यूट्रल पार्टी अपॉइंट करके, कि दोनों पार्टीज आपस में सेटल कर पाती हैं कि नहीं. तो दोनों पार्टीज
बराबर.
को बोला जाएगा कि आप लोग सेटल कर लीजिए, खत्म करिए, कंसिलिएट
हम्म.
करने की कोशिश की जाएगी. अगर कंसिलिएट नहीं कर पाती है दोनों पार्टीज, तब वो आर्बिट्रेशन में रेफर कर दिया जाता है. तब एक
बराबर.
आर्बिट्रेटर अपॉइंट हो जाता है. फिर आपको स्टेटमेंट ऑफ क्लेम देना होगा, अपना पूरा क्लेम डिटेल में देते हुए कि ऐसे ऐसे हमने इनको दिया था, ऐसे ऐसे मेरा इतना पैसा बनता है. मतलब जो भी आप मांगेंगे आपको उसको प्रूफ करना पड़ेगा वहां पे, कि मेरा इतना पैसा बनता है और ऐसे बनता है. और फिर ऑपोजिट पार्टी को अपना डिफेंस में अगर कुछ देना होगा तो वो देगी. हम लोग
हम्म.
अपना एविडेंसेस देंगे, आर्ग्यूमेंट्स होगा, उसके बाद जो आर्बिट्रेटर है वो एक अवार्ड पास कर देगा. तो
बराबर.
यही है नॉर्मल प्रोसेस है.
ओके.
हाँ.
हाँ जी, मनीष जी.
Yeah, evening Pratik. I'm
हाय
Mani,
हाय मनीष.
and we are dealing mostly with the multinational companies.
ओके.
I have a problem that due to some goof up in the company, and it's a beauty industry. We are manufacturers and making retail displays.
Okay.
So our payment got stuck up because they were telling us ki, we are doing the auditing, and probably after that everybody is on hold. So once it is clear, and then we will make the payments.
Okay.
So it's been almost a year now that our
Okay.
payment is stuck and the work got stopped, and there is a huge payment involved. As I mentioned that one, my payment is stuck, then the POs which we have got and the stock is ready, that is also not being moved, right?
Okay. So they're not accepting your work also now.
No, no, it is not that they are not accepting, but they are not picking it up and they are not replying to it. And the ready
Okay.
stock is also worth many lakhs.
Okay. Matlab they're not as much diligent with the work that as compared to you,
No, no,
right?
the work has no problem. The quality has no issue. The only thing is nobody is responding from the junior
I
level
got
to
it,
the
because just
senior
because they
level.
have liquidity crunch, they are not taking over from you.
I
They are
don't know
not.
whether they have a liquidity crunch, or what we got to know is that some person in the company who was dealing with us and few other suppliers goofed up in the system, though he has been suspended from there, and everything is under the forensic audit now.
Mhm.
So, but we told them that, beside everything, we have paid GST on your behalf, number one, which
Yeah,
you
yeah,
have claimed. At least
yeah.
release that money. And if there is any goof up and the payment pending is including the stock and the POs, and it is in crores of rupees.
Okay.
So release some interim so that our system should not, suffer because of it.
Sure,
Right.
Manish. I
And the
understand.
other thing is ki, though the entire conversation is on mail, and I was making it a point that everything should go on record, so that tomorrow they cannot deny or go back on words what they are saying. The other thing is they confirm me some order on mail, because our association with the company goes around 20-25 years back.
Okay,
So
okay.
on the good terms without the PO, but on the confirmation of mail, we did some work,
Mhm.
keeping the timelines that it has to go pan India so that it should not delay the process. So we did that, and we were promised that within 2-3 days. It was probably Friday when we got the confirmation, and we were supposed to, or Thursday. So we were supposed to get the PO on Friday or Monday,
Hmm.
but we initiated the work. And now the thing is they are not replying on to this also, though everything on this subject is also on record. Plus one of my question has already been answered, that the WhatsApp communication is admissible by court of law.
Hmm.
So now how would you help us in or you can guide us in getting our payments?
So I believe that your issue is that they are not paying you, or not they are replying to all the other concerns that you have with them.
Correct, correct.
Yeah, right. So it is if you want to proceed legally now, because as you're saying that it's been 1 year and you have been following up with them, but they're not getting back. So you'll have to decide if you want to, given your association, which dates
That
longer
is
than
that is exactly where we are skeptical whether to take this step
no, you
to
you
spoil
you for an
the.
for a communication, what you can do is, you can write a communication from your letterhead only. First, you write a communication on your own letterhead saying that we are not intending to take any sort of legal action first, and we want you to really take care of this, take note of this, that we are facing this much of losses. Kindly give us the payment, and please get back to us with all of these concerns that you have, because failing which will be constrained enough to take legal actions against you, because we are facing enough losses, and this is the liquidity we want, because we are facing the liquidity crunch. So it cannot be on our detriment. You just are sleeping on our conversation, and we are detrimental, and we are getting severely affected on the other hand.
So
So it cannot be.
though this has been conveyed repeatedly on the mails and the WhatsApp that we are going through huge financial crisis, you just try to switch over the shoes and put yourself into it, and then realize how will you feel if you are not even paid for 3 months? You will probably shift the job. So we are
Sure.
cooperating with you in every damn respect. You are asking us to send the bills now from last 5 years, 6 years, ever since that particular guy has joined in. So every damn detail we have provided, but
Mhm.
still there is no respite, and but there's so much emotional, and everything we have
Then
conveyed.
I'll suggest you, Manish, that you start with a legal notice. I'll suggest that you do not start with a very strong worded legal notice, uh, giving them threats of initiating.
On a softer note, I did mention that we are registered with MSME, and probably you RCA and MSME, we are getting the mails and things that why our payments are not getting in. But they didn't give any heed to anything.
Sure, that is why I'm telling you that you give them a brief of the claim that you can ask from them if your
Mm-hmm.
relationships goes sour.
Mm-hmm.
So just because your relationship is good, you are not pressing upon the claims of interest payment and all of those payments that you can. So
Mm-hmm.
now give him a brief rough of estimate that you might claim from him if
Mm-hmm.
you do not have any other option left but to move legally. So tell them that if you are moving legally, you will move with all that there is to claim,
Mm-hmm.
right? So then it wouldn't be compromise or it wouldn't get settled. So you will have to be like ki, if our relationship is good, if I'm honoring your words and assurances for a longer period of time, it is now your turn to honor those assurances, right? And if you kept sleeping over your rights, kept sleeping over our communication and would not take seriously our
Mm-hmm.
demands, then
Mm-hmm.
we'll be constrained to take legal actions, and we have the rough estimate of all the claims that we have, and this much is the rough estimate. So
Mm-hmm.
you tell me that you want to amicably resolve it or you want to fight with this much of amount, because
So
I
should I?
wouldn't claim this much of amount if it were to amicably resolve, right?
Okay.
Yeah.
Should this be conveyed on mail or WhatsApp, or how should
No,
I convey this?
it is good that if it is conveyed on a on a in a legal manner, if an advocate sends it.
On okay, fine. Matlab, it has to go through a professional thing,
Sure,
not even
sure.
on mail.
Yeah, sure.
Okay. Then one more thing.
Mhm.
What if I don't do such thing and wait for my payments to come in, as they have promised that you will be getting major chunk on 15th, though they have been making promises earlier also.
So
So.
write a mail to them saying that if basing on your assurances, if I do not receive the
Hmm.
payment as you are
Hmm.
stating in your email,
Hmm.
firstly take an acknowledgement from them. Take
Hmm.
an acknowledgement, unequivocal acknowledgement from them that this much of amount I have to give you.
Hmm.
Okay. If they provide you the acknowledgement, ask them to give
You know,
you a
when
deadline, a timeline under which they are gonna give you the payment, and write a mail saying that if you do not get this much of payment in the timeline stated
Mhm.
by you
Hmm.
yourself,
Hmm.
you will be reserving your right to claim all the delayed payments and all the delayed interest
Hmm.
component which is
Hmm.
there on the delayed payment.
Okay. And
And then
if
you write that mail and you send it across.
okay,
So at a later stage of time, if they do not make you payment on the prescribed timeline, you can still uh, go behind them with all that there is.
okay, given a scenario, if they pay, so can I still claim the interest, or the loss of capital and cost of
Sure,
warehouse?
if you can prove the losses,
Hmm.
and if there is delay in the payment and you can prove that there is a delay in the payment, then
It is a
you
clear
can
cut
ask for.
delay, whereas their our payment terms clearly state that the payment will be made after the submission of the bill, and their PO clearly states that the payment will be made in 15 days.
Sure. Then if the payment is not made, you can go for the delayed interest component to MSEFC. But MSEFC does not often deals with the loss components or the components arising out of the breach of the contract.
Okay. No,
It
but
only deals with the issues of delayed payment.
I'm
okay.
sorry to interrupt here. Actually, the session is just getting close, so I just need 2 minutes to
Munish,
conclude the
do one
session.
thing. No, you can send the documents across to me, and
Okay,
I'll
fine.
I'll go through the documents and we'll get on a call in a more detailed
Sure,
manner.
definitely, Pratik. Thanks a lot. Thanks for the
No
time.
problem. No problem, Munish.
Thank you.
Thank you, Pratik ji. I
Thank you,
really
Sonia.
would like to extend my gratitude from the entire team of UDYAMITA and all the participants whom you have really answered and shared so much information. So I would also request all the participants, there are a few questions which couldn't be answered here, but you have our number. We have shared the number. You can just get in touch there directly and we will help you get in touch with Pratik ji and he will assist you for all your queries. So just be patient after the session. We are still there for you.
Thank you, Sonia.
And Pratik ji, would you
It's
like to say
always a
something
pleasure
to the
to speak.
participants?
And thank you for all your support. Thank you. So
Thank you from all of us here. Thank you for joining us again.
thank you.
Thank you.